Welcome back to The Explainer. Today we're unpacking the totally fascinating and, let's be honest, sometimes pretty severe evolution of property taxation laws here in Ghana. We're going to trace exactly how local authorities figure out what you owe them for that roof over your head. And you know what? You might actually be surprised by just how drastically the rules of the game have changed over the years.
So let's just dive right in with a super quirky historical reality. How would you feel if your property tax bill depended entirely on how much sunlight you let into your house? Imagine being taxed just for having windows, basically paying a premium for fresh air. It sounds like something straight out of a bizarre fiction novel, right? Well, it absolutely wasn't.
Back in the colonial era, this was very real. It was actually known as the Nentoku Rotu Tauru, or the window tax. Local rating authorities would literally compute your property tax just by counting up the number of windows in your building and then multiplying that by a basic figure. It's crazy, but the more windows you had, the more you paid. It was definitely a crude, but I guess very literal way of measuring the value and size of a property back then.
We've organized this explainer to trace this whole journey in 4 parts. First, we'll look at colonial-era rating origins, then post-independence tax reforms. After that, Act 936 and modern rating. And finally, we'll wrap up with enforcement and strict penalties.
So let's jump right into Part 1, Colonial-Era Rating Origins. Moving past that wild window tax, the colonial government eventually empowered urban and local councils to collect rates, much like municipalities do everywhere else in the world. Their main tool for assessment under the old ordinance was something called the Annual Rental Value, or ARV. Essentially, the councils assessed your rates based on what your property could theoretically earn in rent over the course of a single year. If your property was highly rentable, well, your taxes went up. Moving right along to Part 2, Post-Independence Tax Reforms. Now, as the nation grew, that old rental-based system really started to crumble under its own weight. We transitioned from that outdated ARV basis, moved on through the incredibly transformative Murray recommendations, and eventually arrived at our modern era with the Local Governance Act of 2016. That's the one commonly known as Act 936. You're probably wondering, why the big change? Well, the Murray recommendations strongly advised completely abandoning that annual rental value system. It was honestly just chaotic. You see, a lot of rents were strictly controlled under the Rent Control Ordinance, while others completely weren't, and that created these massive, glaring inconsistencies. Plus, the ARV system actually acted as a disincentive to developing your property to its highest and best use. And frankly, there just weren't enough qualified valuers around to do all those complex rental assessments anyway. So, the solution? The Depreciated Replacement Cost, or DRC system. This was a total game changer. Instead of trying to guess unpredictable rental markets, the DRC looks at the objective physical entity, literally the bricks and mortar. It bypasses all those messy questions about land title and tenure, and crucially, while local market data was really scarce, construction cost data was widely available. So this allowed for a much more uniform application across all different types of properties. That brings us to Part 3, Act 936, and modern rating. This is where our current legal framework gets really interesting. Under Act 936, district assemblies hold absolute exclusive power. Crucially, a district assembly is the only authority that may levy rates for a district, and that holds true despite any customary law that might say otherwise. Their main duty is to levy rates that are strictly sufficient to cover their total estimated expenditures for the period. But they can even levy additional rates to cover previous debts or unexpected contingencies. Now, the law recognizes 2 distinct modes of rating. First up is the general rate. This one is payable by the owner of the premises based on the rateable value, or it can even be assessed on the actual possessions of the residents living in that district. Then there's the special rate. This is basically a standard amount payable by persons aged 18 to 70 who reside in the area, or it can be an amount imposed specifically on the owner of movable or immovable property. And a quick side note here, when fixing this basic rate, the district assembly is actually legally required to consult with district-level stakeholders first. So how exactly do they do the math for your specific house? Well, the Lands Commission, or a specially appointed valuer, is tasked with determining your property's rateable value. Building right on those Murray recommendations we talked about earlier, Act 936 defines rateable value as the replacement cost of your buildings or structures, minus the cost of restoring those premises to a condition as serviceable as when they were brand new. So to put it simply, it's the depreciated replacement cost. But here is a really fascinating statutory limit that the law places on this value. If you actually live in your own home, meaning it's an owner-occupied premises, the rateable value is strictly capped at a maximum of 50% of the replacement cost. That is a fantastic built-in protection designed specifically for everyday homeowners. However, in stark contrast for any other case, which typically means commercial properties or homes you're renting out to other people, the rateable value is set at a minimum of 75% of the replacement cost. So the financial gap between living in your house and making money off your house is drastically reflected in how you are ultimately rated.
And that leads us to our final section, Part 4, Enforcement and Strict Penalties. We really need to talk about what happens if you just don't pay, because the escalation process is incredibly severe and direct. It all starts with a 42-day warning notice physically affixed to a conspicuous part of your premises. If you ignore that notice, the district assembly doesn't mess around. They go straight to court to apply for an order to sell your premises. A judge will hold a hearing, and if they're satisfied that the rate is still unpaid, the court literally orders the sale of your property. If the sale goes through, the purchaser is granted a certificate of sale. Yep, your property can literally be sold right out from under you just to settle local taxes.
And get this, it's not just a civil matter. Act 936 outright criminalizes noncompliance. If you refuse or willfully neglect to pay the basic rate, or if you make a false statement about your rate liability, or even if you incite others not to pay, you are looking at a fine of up to 25 penalty units, up to a whole month in prison, or, worst case scenario, potentially both on summary conviction.
So yeah, district assemblies don't just sell your house, they can actively prosecute you for willful default. And here is the real kicker for anyone thinking they can just easily fight this in court. The law explicitly states that the district assembly's official rate books, once signed by the district chief executive and sealed, serve as first instance evidence against you. The burden of proof shifts heavily onto the citizen.
Now, let's look at how this bleeds into your everyday working life. If you think you can just fly under the radar, think again. Act 936 actually enlists your boss to collect for the district. The law mandates that employers must deduct these general or special rates directly from an employee's paycheck. This applies if you simply reside in the district or if your employer knows you own property there. Once that money is deducted, the employer has exactly 30 days to hand those funds straight over to the rating authority.
We really have come a long, long way from counting windows, haven't we? Today's system is highly organized, objective, and, as we've seen, incredibly strict, and it leaves us with a critical question to ponder. While these taxes are undoubtedly vital to running our local districts and providing essential services, does this strict enforcement, including the potential forced sale of a home or even prison time, actually strike the right balance with the everyday citizen's livelihood? That is the complex reality of Act 936. Thanks so much for joining me on this deep dive in the explainer, and hopefully this helps you understand exactly what's behind your very next property rate notice.